looks like I'm living rent-free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown-up here? Oh right, it's me. Let's go. Call me Daddy, yeah, that's who I am. Running your mind's like a master plan. Papa Nut, Shizzy Daddy, take your pick. I'm owning in your thoughts while you still act sick. Call me Daddy, it's what you mean. While you chase the crust and I take the lead. Living rent-free, that's my name. Go ahead, say it, put some respect on your name. Man, I'm too old, well here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants, stuck in your headspace with no end to sight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm holding your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm the VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right, spinning your wheels while I'm out of sight. You think you've got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent-free, and you know it feels good. Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
Hey chat, how are you doing this evening? It's so good to see all of you. Oh my god. Yes. The interesting thing about my Tug and Megan's today, it is, oh my gosh, Emma, that's awesome. I'll get to that here in a second. This is going to be a really fun one. I've got not one, 2 letters for you in a short story. They're going to be quite fun. And it's going to be more than you were expecting. Let's put it that way. Oh my God. I saw this document and I was just like, this has got to be a joke, because I thought initially whenever I pulled it up that there might have been something there. And I asked a few questions to people. You know, it's one of those where you're just like, something seems a little bit odd. So I went back and I did a little bit of digging. And I was just like, what exactly is this? And whenever I saw it, I was like, okay. And so I read through this document. Now, this is the actual first pleading from what you saw that Tug and Megan were reading from. It's from the same case. And as I was reading down through it, I was like, something looks really familiar about this. The little border on the side, the way that it's put together. And then I started reading down through it, and something stuck out at me, which was really interesting. It's really interesting. So this whole guardianship, probate enterprise, blah, 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 continues on with this kind of stuff. But it came down to this little piece right here. this little piece of information right here. This SC code 1617640 extortion. Okay. Now, when I saw that, it gave me pause, because this is a Florida court. Okay. And there's certain things that you wouldn't need to bring up in a Florida court. So what I did is I grabbed this document and I threw it through a little search pattern. And this search pattern came back telling me, most generally, this particular document. Now, I can't confirm it because I wasn't there when it was written, but it was partially written by a human and partially written by AI, by generative AI. And the reason it said that is, because whenever the little search that I did on it, which was really, really interesting, and I want to quote it properly. So give me just a second while I find this again, because what it gave me was I didn't have it pulled up. I thought I did, but I didn't. Doggone it. So let me pull this thing back up again, and just so you understand, whenever I looked at this, it wasn't just to really, bring anyone down or burn anyone. Oh, come on, it locked my mouse up. But what it said is it put a flag down on it, on that particular one. And the reason that it did is, whenever you put all of those citations together, like every single one of those citations as a whole, it says that the writing was most likely generated or drafted with heavy AI assistance, possibly edited by a non-lawyer who doesn't fully understand legal pleading standards. Now, one thing that it pointed out in that is that there were a lot of procedural deficiencies, long-winded narratives, misaligned jurisdictional claims, and poor citation control, which meant that they were lazy. Whoever did this was lazy as all get out. And what it said is that the document references a South Carolina code, extortion. It says it's a South Carolina statute, but the lawsuit is in Florida federal court, unless the defendants are based in South Carolina or the conduct occurred there, which the document doesn't clearly show. The citation is irrelevant, possibly copied from a template or an AI hallucination, which raised another flag on there. And it said the way that the AI, it could tell that it was AI is because it put in there what the question would have been for somebody doing this. And that's what sort of threw me off. I was like, holy cow. It says, let me see if I can find that particular, because it was very, very, very well put together. It just, what it said, I couldn't quite repeat it exactly, but my search algorithm said that it was boilerplate, no real evidence or linkage. It also stated AI tends to overemphasize legal terms without specificity, which means it's not very specific on exactly what it is. And it also says that that particular one would be a specific question that you would ask AI, and it would spit out all of these statutes. If you were doing something for Rico, it would spit out all of these statutes. And they said it's very indicative of AI doing this, which was really interesting to me. So I went and I grabbed the next document, which was this one right here. This is the one that was ordered on. It was the third amended complaint demand for jury trial. Whenever I put this one in there, it said pretty close to the same thing. It said that there's no specificity in any of the language that's happening. And it was possibly edited by an attorney, that there was an attorney involved in it, but there was so many inconsistencies in it and so many things that weren't matching up that it's a possibility that whoever wrote this might have gotten in trouble already for using generative AI, and they were trying to cover up their trail, which brought me back to the original reason why I did the search on this particular thing that was filed in 360. And whenever I read that one, I was like, this is almost saying the exact same thing. It was an AI hallucination. And it's not the first time one of these kinds of things have happened. Attorneys have gotten in big trouble for this. And I would suspect that if Judge Hinkle had been known about this, or somebody would have even brought this up, it would have probably had a little bit of a different outcome on this particular motion. So it would be really interesting to see. It would be really interesting to see what the filing's going to be from all of the plaintiffs in this, or all of the defendants in this particular appeal. And you have to remember, this was an appeal that was written. This one right here was the order that was dismissing the third amended complaint. Not only did they do that, they were just saying, no, nothing about this is good. And he says, the case before the court motions to dismiss the third amended complaint is an impenetrable mess, as egregious a shotgun pleading as has ever hit the docket. Order dismisses the action on a basis, notes alternatively that the complaint fails to state a federal claim on which relief can be granted. Dismissal would be appropriate on that basis too. And I'll hit you guys all here in a second with the super chats and everything, and the memberships. I'm just trying to get past a couple minutes here because this is a crazy one. Now, as you go down through here, and it says it's railed against having shotgun pleading. It says it doesn't like this crap at all. Resolving cases on the merits with each side taking its best hold has been my goal through the years. With sound case management, issues can almost always be framed adequately, if not with precision, and cases can go forward. Which leads me to wonder if there's other attorneys that are doing this kind of stuff. Makes me think, are other attorneys using this kind of thing? I have denied dozens of motions asserting complaints where shotgun pleadings, and I have granted leave to amend in dozens of other cases so that shotgun pleading deficiencies could be cured. So what he's saying is this judge has seen shotgun pleadings like this before. It's not abnormal. And usually what he does is he grants them leave. He says, amend your pleading. And I'm going to give you 30 days to fix this. And, usually they'll come back and they'll remove things out of there that are unnecessary or burdensome. Because you have to understand the initial complaint, this complaint right here is a 135 pages. And what they're doing is they're hoping that nobody reads it, or it takes so much time to read it that they can just run up their bills. And that is the other thing. I mean, if you're going to run up bills, what's a better way to do that than by spending, saying, well, this is 137 pages. It must have taken me hours to write, but never actually spending any time doing it, because if you're just dumping a whole bunch of AI in there and it does most of your writing, then shit, you're pretty much done. Hey, welcome, Mug and Tug. Good to see you. Good to see you, Raiders. Good to see you. Now, declining to dismiss a complaint as a shotgun pleading, and he has his citations here. Denying a motion to dismiss the asserted complaint was a shotgun pleading. Upon receiving motions to dismiss, setting a hearing to address the shotgun pleading issue, and after the hearing, granted leave to amend, after which the case went forward on the merits. Now, that's the biggest thing that these judges are looking for. Welcome, Raiders, welcome. Is he wants this to move forward on its merits. And he was looking at this, dismissing a complaint as a shotgun pleading, granting additional leave. And he turns around and says, this is a rare case. There might never have been a more egregious shotgun pleading than the original complaint. The original complaint, this complaint right here, this one that I pulled up that looks nothing like this one. You notice the borders are gone on this, but you got these borders on this side right here. Why would that be? I mean, the font is completely different. You got a different font here than you have for this one. And they look completely different, like a different person wrote this entirely. And they're saying even the amended one is a complete shot in the dark. And he says, there were 3 amended versions tendered in this case. Okay. So you've got the original pleading, and then you've got 3 more amendments to it. So there's 4 pleadings. None of the deficiencies were cured in any one of these. And see, what brought this to my attention was I just wanted to see what the order was. How did the judge find? What did the judge see? And whenever, actually, it wasn't even that. I looked because apparently this isn't done. This case is not done. The plaintiffs in this case, whenever you see the amount of plaintiffs in it, and I'll show right here at the very top heading of this one right here that explains this right here are the plaintiffs, are the defendants in this case. Now, this is for as you can see, you've got one person right here, or potential beneficiary, versus the state of Florida, which means the entire state of Florida, and all of these people below. You got this one professionally, individually, professionally, individually, professionally, individually, professionally, individually, professionally, individually, professionally, individually, the law firms, which that right there would be a law firm. Hewler Wakeman, Solomon Law Group, PLLC, Tapestry Senior Living, Assisted Living and Memory Care, Tapestry Companies, Cherry Laurel, Holiday by Atria Management Company, Leon County Clerk of Court, which is where this was filed at, Florida Department of Health, Florida Bar Association, State of Florida, Dr. Paul Katz, professionally and individually. All of these people are named in this. Welcome, Mug Raiders. Welcome, welcome, welcome. So whenever you see this many things, they're throwing things in there that are absolutely insane. And then, of course, you've got this right here, which is for actions and violations of Organized Crime Control Act of 1970. And they're trying to throw all of this stuff in there. And then common law claims. This is an absolute shotgun pleading. And the judge wasn't happy about this at all. He says the order granting leave to file the last of these, the 3rd amended complaint now before the court, warned the plaintiffs of the circuit's shotgun pleading prohibition and provided citations to several circuit decisions setting out the governing standards. And he's very specific here. Warned the plaintiffs of this this shotgun pleading prohibition, provided citations to several circuit courts setting out the standards of which they could file. The order noted that a primary reason for the prohibition is the need to make clear which allegations of a complaint apply to which defendants and which counts. Any Third Amendment complaint must be short and plain and must conform with the law of the circuit on shotgun pleadings. The judge was very specific to him on this. He said, don't play around. Don't play with me. I'm not playing. In response to the order, the plaintiffs filed the Third Amendment complaint for convenience. This order often refers to it as simply as the complaint. It is not short or plain and does not conform with the law of the circuit on shotgun pleadings. Quite the contrary. It is as bad as the prior versions, or nearly so. It is an impenetrable mess. It spans 135 pages and includes 453 numbered paragraphs, not counting subparagraphs and unnumbered text. It cites documents and exhibits that were not included with the filing, and the defendants say were not served on them in response to motions to dismiss based partially on the absence of allegations of fact. These were facts that they couldn't put in there. The plaintiffs say they provided voluminous, tangible, and factual detailed support for their claims as an unspecified location within 1,139 pages of material filed previously. The plaintiffs say they provided voluminous, tangible, and factual detailed support. Some of the material could perhaps be considered on motion to dismiss. Much of it could not. And more importantly, at this point, the plaintiffs cannot cure the complaint's shotgun pleading violation by suggesting the court and the defendants plow through voluminous, extraneous material in search of facts not properly included in the complaint itself. The mass of unorganized material not tied to any specific defendant or court compounds, it does not cure the shotgun pleading problem. The reader of the complaint, with or without the separate materials, is left to guess which allegations relate to which counts. Successive counts incorporate prior allegations with little rhyme or reason. See Third Amendment complaint, ECF 14. At paragraph 64, 192, 196, 78. I mean, it just goes on and on and on. And what he's and if you're wondering what he's saying, he's talking about the actual paragraphs here. Page 64, which would be 192. And we'll just pull this up. Go down here to page 64. As you can see. 192. All enterprise members use funds generated from the enterprise to continue to fund their business while waiting for their next victim. What does that mean? What does that mean? There's nothing that they're citing back to in the documents that they gave. A cyborg order part, human part tech. I think you'll get in a sneak peek at the song just brought. $2, about $2 cars. Thanks, Rosella. It's time for the song. Yes, it is. Let's break out in some song and dance. And
welcome to the shit show. Every single day, a new flavor of fuckery. 'Cause everybody sucks, you see, and they're dumber than a bag of clots. Monday, bullshit. Tuesday, bullshit. Wednesday, hey, what the fuck? And then 4 more days of increasingly stupid, ridiculous, ignorant, boulder, dash, poppycock, bollocks, and fuckery. Yeah, we're all over again.
And also for Angie did it. Else she has become a YouTube member yet again. She is absolutely wonderful. Thank you, doll. I appreciate you so much. And we've got another one here that has been a member for 9 months. Thank you so much. Good evening. And did I just give birth?
Welcome to the shit show.
No.
Every single day, a new flavor of fuckery. Cause everybody's such, you see, and they're dumber than a bag of clots. Monday, Tuesday, Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant, boulder, dash, poppycock, bollocks, and fuckery. We'll do it all over again.
Emma, can't stay though because I'm getting a tattoo today, tomorrow, so it is Aaron's day today. Happy reading, and I will have some happy reading. Trust me, this is one you are going to want to go back and watch. If nothing else, it'll all be explained later why you want to come back and watch this. It's going to be good. I love that song. I love it too. Welcome, Mug Raiders. Welcome, Mug Raiders. Now, as I said, judge not too happy about this. As a reader, and a reader is sometimes left to guess which plaintiffs assert claims against which defendants in which counts. The complaint makes little effort to mask this, often referring to the plaintiffs or defendants, and thus leaving the reader to guess whether the allegation relates to one plaintiff or more, or to one defendant or more. If more than one, the complaint leaves the reader to guess which ones. This is do your best to figure this shit out. And that's exactly what he was doing, saying precisely the kind of thing the shotgun pleading principle prohibits. With broad conclusions but few facts, the complaint alleges that 23 defendants, 23 defendants, engaged in a racketeer influence and corrupt organizations act enterprise, whose purpose was to fraudulently deplete a now deceased individual's assets and the estate that is being administered in a Florida state court. Some of the allegedly fraudulent actions, though not all, were approved by the state court. Indeed, the complaint alleges the court assisted in the enterprise. Now, he says the state court's approval matters, as the order granting leave to file this version of the complaint warned the plaintiffs. The plaintiffs should note well, there are limits on a federal district court's ability to interfere with ongoing state court proceedings in general, or with state court probate proceedings in particular. Addressing the probate exception to federal jurisdiction, and under the Rooker-Feldman doctrine, federal district courts cannot hear cases brought by state court losers complaining of injuries caused by state court judgments rendered before the district court proceedings commenced, and inviting district court review and rejection of those judgments. Now, he's being very specific on this. And that would be because this is the way that it works in that particular area. They don't want federal courts interfering with the lower courts whenever these things have already been done, because then it calls into question what they're doing. He says the complaint's vague allegations haphazard incorporations by reference make it impossible to sort out which parts of the claims are barred by these principles. Many of the complaint's conclusions, including apparently a veiled suggestion of murder, are unsupported by factual allegations, plausible or otherwise, for all but 3 primary defendants. Do you hear that? Unsupported by factual allegations, plausible or otherwise, for all but 3 primary defendants. And the complaint is completely devoid of factual allegations showing or supporting any inference that the defendants knew of, let alone participated in, any misconduct or conspiracy. And it's no different than that bullshit lawsuit that was 115 pages that was filed in the state court adding Megan, Tug, J Hip, and 10 John or Jane Does unnamed. That was a complete shotgun pleading, and I'm surprised that the judge even let that crap in. When you get in the mood for another song, the dance song, please. I'll get you a little bit of dance song. Something like
Dog will hunt.
just kidding. Fraud must be alleged. Now, this is really important. Fraud must be alleged with particularity. But here the allegations of fraud would not pass muster even under the relaxed standards applicable to other subjects. The plaintiffs seem to have sued almost everybody who dealt with the decedent. His health care or his estate. Even for the three primary defendants, the complaint's factual allegations are not sufficient to state a claim on which relief can be granted. A classic shotgun pleading is a complaint that contains multiple counts where each count adopts the allegations of all preceding counts, causing each successive count to carry all that came before and the last account to be a combination of the entire complaint. Another type of shotgun pleading is one that asserts multiple claims against multiple defendants without specifying which of the defendants are responsible for which acts or omission or which of the defendants the claim is brought against. Further shotgun pleadings include complaints that are replete with conclusory, vague, and immaterial facts not obviously connected to any particular cause of action. The complaint violates every damn one of these principles. 10 of the 12 counts incorporate all preceding paragraphs, including those in prior counts, and this makes it impossible to know which counts are brought against which defendants. The complaint uses the terms enterprise and defendants generally, making it impossible for those allegations to know which defendant allegedly did what. The complaint is replete with conclusory, vague, and immaterial facts. Is especially true considering the plaintiff's reliance on mass of unorganized additional materials. Play a great song. I will play a great song. Maybe not. We'll even do a little dance for it. How's that? We'll even do a wonderful dance. And you guys are just jonesing for a song, aren't you? All right, give me a second. I'll see what we got here. It's not this. It's this. This is what you want. I know what you want. You want the stream dance. All right. You ready for a stream dance? All right. Hold your little horses. Here it comes. And you got 3 minutes and 11 seconds to dance. And this is for you.
Time to shine. I'm feeling the groove with these hips of mine. Hands in the air like spaghetti gone rogue. My knees are jelly and my hips just broke. Shaking it, breaking it, what a blast. Wobble it, wiggle it, shake that ass. Do a jig or a jog, wiggle it to the side, or break that hip by moving your ass. Step up or stand aside. My shoulders pop like a rusty hinge. My fingers point like they're on a binge. Twirl like a tornado, then drop real low. It's not planned, it's a shit sideshow. I've got the rhythm of a clock that's broke. My dance floor moves are a big effing joke. Shaking it, breaking it, what a blast. Wobble it, wiggle it, shake that ass. Do a jig or a jog, wiggle it to the side, or break that hip bone by moving your ass. Step up or stand aside. can't help but watch me steal the show. I summon the shake, the shimmy, the twist, a mix of genius and a big old fist. You're drawn in close, your feet start to twitch, feeling the groove like a broke-ass bitch. Yeah! Shaking it, breaking it, what a blast. Wobble it, wiggle it, shake that ass. Do a jig or a jog, wiggle it to the side, or break that hip bone by moving your ass. Step up or stand aside. Now we're all in the shake, no need to be shy. Move like spaghetti and reach for the sky. We'll dance like we're cursed, laugh till we're sore. Shizzywhiznut reigns forevermore. So join the dance, let your weirdness unfurl. We're shaking ass, not a care in the world.
There you go. Maybe not. That was for Happy. Get to feeling better, Happy. I miss the morning shows in this tune. Oh, well, just think. Tomorrow morning, I'll be over on Mo in the Deep Ends. That's where I'm going to be with Mo in the morning. And the morning shows will come back. They will come back eventually. Don't you worry. They will be there. Did you play that just for you? I played that for Happy right there. I played that for Happy. 0121. Welcome. And yes, that she was feeling sick. She needed a little bit of dancing music. Now, this is awesome. The judge says if ever there was a case that should be dismissed with prejudice on shotgun pleading grounds, this is it. This order could end at this point. Like I could stop telling you guys about this, but even if not dismissed as a shotgun pleading, the complaint would be subject to dismissal on alternative grounds. The remainder of this order addresses some of the complaint's other deficiencies and, in addition, attempts to preserve some of the perspective that has been gleaned through many hours trying to sort this all out. Oh. The standards on motion to dismiss, he goes through those. Motion to dismiss is not a vehicle by which the truth of the plaintiff's factual allegation should be judged. Instead, it remains true. Twombly, while federal courts and litigants must rely on summary judgment and control of discovery to weed out unmeritorious claims sooner rather than later. Says the record, the complaint must stand or fall of its own factual allegations with this exception. Proper attachments, narrow category of other materials must be considered. Here, in addition to its own voluminous and sometimes virtually incomprehensible allegations, the complainant refers to other materials not attached to or properly cited with specificity in the complaint that the plaintiffs say count towards the required factual allegations. Defendants say the plaintiffs have not served or otherwise provided them copies of the materials. In addition, the plaintiff's responses to the motions to dismiss refer without pin sites to an earlier filing. 8-1 consists of 1,139 pages of often irrelevant materials. The plaintiffs assert these materials, too, count towards the required actual allegations. Some of the defense have also filed extraneous materials. Some of the materials could perhaps be considered on the motions to dismiss, but some plainly could not. This order includes citations where feasible in an effort to make clear where information came from. In an attempt to allow a reader to make sense of this complaint, some information is included here as background, even though not alleged in the complaint or included in properly considered additional materials. That background information has not affected the decision. Right here. This is some of it right here from 8-1. On February 11th, the plaintiff filed a motion to amend, providing voluminous, tangible, and factual detailed support for the allegations. The court granted leave to amend on February 12th, and pursuant to this order, plaintiff filed their third complaint on March 2nd, 2025. February to March. less than a month later, which incorporated by reference the previously filed exhibits from Doc 8-1, a copy of a written instrument as an exhibit to the pleading and is a part of the pleading for all purposes. In the course of consistently held that documents incorporated by reference in this matter become part of the operative complaint. This was their response to the motion to dismiss. 49 at 2-3, the statement is incorrect or misleading on several aspects. First, the February 12th order explicitly denied the plaintiff's motion for leave to file the second amended complaint. Do you hear that? February 12th order explicitly denied them to file a motion for complaint. The order most assuredly did not suggest the materials attached to the second amended complaint, that is, the materials in 8-1, were properly before the court or could properly be incorporated by reference to a third amended complaint. That's both B and not the B. I love it. Shizzy looking exceptionally rugged tonight. Rugged. Well, thank you very much. I appreciate you, Gutters Pub. You know you like the rugged, manly men. You can't help it. Second, the third amended complaint does not even cite 8-1 or provide any clear reference to any specific part of 8-1. The third amended complaint sometimes has footnotes referring to materials, but even in those instances, it doesn't provide unique exhibit numbers or pin sites or any other means to locate the reference material. An example of the confusion, a footnote in the complaint refers to Exhibit A, but ECF number 8-1 has 8A exhibits. Marked A1 through A8. 8 exhibits marked A1 through A8, and the footnote does not specify which, if it refers to any. If it is even the correct one. Other materials referred to in the complaint are not included in ECF 8-1, apparently have not been served on or otherwise made available to the defendants. So basically, it's no different than whenever these assholes decided to file a shotgun pleading in state court and then sit there and expect anybody to make any damn sense of it, let alone any sort of reference to anything that anybody did wrong. And hell, they didn't even send out a damn, a cease and desist letter properly. What idiots. Like, it would have failed right then and there. Bar complaint against the defendant, sketchily, an apparent irrelevant document not included in this or anywhere else in the record. The plaintiffs are wrong when they suggest the court and the defendants can be required to go through ECF 8-1's 1,139 pages of often irrelevant materials in search of voluminous, tangible, and factual detailed support for the plaintiff's claims. Just, are you getting the gist of all this bullshit? I mean, they've got materials that the plaintiffs rely on that are not attached to the third amendment complaint or otherwise accessible or not part of the pleading and are not properly considered on the motions to dismiss, but this would make no difference anyway. A substantial portion of the materials are totally irrelevant. For example, an individual apparently sued the defendant, Howard W. Kessler, nearly 20 years ago for alleged defamation having nothing to do with the case at bar. And this is the same bullshit that they're pulling, because right now they want to go after Randy Shockett. They want to go after Randy Shockett's record of something that happened 28 years ago or longer than 28 years ago. They want to bring this into their court filings. They've told you this is what they're doing. They're bringing Randy's record from 28 years ago, whenever he was a dentist, and they're trying to tie all this back in to Lips's father or some crap like that. This is no, no, trust me. It is not. He is involved in this. If your name is on there, you are the one that is responsible for it. The buck stops right there. He can't throw his wife under the bus on this one, because this document right here is, if you look at this document right down here at the very bottom, it after 138 pages, I don't want to go down here too far, but we're going to go down here far enough that it right here, damn it, right there, it is signed right there. Digital signature, Michael Frederigo's. So he is the one that did this. He is responsible for this. That is his bar license right there. That bar license, that's his responsibility. Yes. Is it possible? I don't know, because he already got in trouble for it once before. I mean, it's going to show that this right here, because the initial perfectly fits, it's up to in his eyeballs. Yes. MF, absolutely. From that case, they're included with no explanation. The case apparently was settled with no findings of liability. Similarly, random medical records from other patients that aren't even included in this, that are not part of this suit, are included in this. One, perhaps to show that Dr. Kessler served on a state court medical examining committee, which is undisputed. Also in ECF number 8-1 are minutes of numerous meetings of the boards of directors of Friends of the State Park. Again, totally irrelevant, but included in the exhibit with no explanation why this shit's here. If there's anything relevant in ECF 8-1, the plaintiff's message to the court and defendants is apparently, go find it yourself. This is what the judge is saying. If there's any bullshit that's relevant, you're basically saying, go find it yourself. This compounds a shotgun pleading violation. Facts. Accepting as true the facts alleged well-placed pleading complaint is usually an easy first step towards analyzing the motion to dismiss. Not so here. Sorting out the facts from a 135-page pleading full of bluster and conclusions is challenging. This order is a best effort, nothing more. The presentation is as organized as follow. The beginning, 2017. April 2018, estate planning. C, 19, decline of the eventual decedent, Victor Lambau. D, September 29th, dispute with Guillermo Lambau. F, October 2019 to 2020, decisions, expenses. G, other complaints. H, state court guardianships proceedings. I, Victor Lambau's death, blah, 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 and on and on. In the beginning, the facts in the section are not included in the complaint, and thus are not part of the analysis or the motion to dismiss, but any reader may find it useful background when attempting to sort out factual allegations about later events, the allegations that matters. Some of the information is also available from state court records that could be judicially noticed after appropriate notice and opportunity to be heard for the limited purpose of showing the course of those proceedings, though not the underlying facts. Florida probate and guardianship dockets are not available online, as you can see right there. Okay. That's why that's how they're getting away with this kind of shit. Oh, we've got something. We got a little something for Felicia later. Yes. I do live in life. I got you. I got your email. I just haven't had a chance to respond. Florida probate and guardianship dockets are not available online, so finding and verifying those records would require further steps. Before going further, a word is in order about the complainant's identification of the scheduling defendants. The complaint's state case styles includes among the 23 listed defendants, Sketchley law firm, the Sketchley method firm. The placement of firm and stray space after law are apparently just typographical or scurvers. Basically, whoever wrote it. The style apparently was meant to include Miss Sketchley, her law firm, and the Sketchley method, whatever that means, but the Sketchley method is not included as a defendant in the text of the complaint. The inability to sort out who is actually being sued is yet another indication that this is a shotgun pleading. And same way with that last document. You know, the last amended complaint they had, you couldn't tell who they were suing for what. It was confusing. The background facts, unverified, not alleged in the third amended complaint, include the following. We're not going to go through all of those. That they died in a hospital. They alleged that they died under suspicious circumstances and that the sheriff's office declined to investigate. The estate planning. Victor's July 2019 decline. And he's basically telling them how to lawyer. He's just like, listen, this is how you lawyer. This is not how you lawyer here at all in any way, shape, or form. Oh my gosh, the letter I have for you on this one is going to be glorious. Only motion to dismiss, not the complaint. They cannot be considered on a motion to dismiss. The allegations are recounted here simply as description of the motion to dismiss. The complaint alleges as following, that all this crap happened. Trust me, we're down to page 20. We're getting through this pretty quick. And then they go into Dr. Katz. And the judge had to spend who knows how much time going through every single bit of this. And he was probably pissed. Just scream. Oh, it's story time, buddy. It's story time. You may have to scream a few times. I may not hear you. Oh, is my volume really low? It doesn't look like it's low on my end, but I can always bring up the volume a little bit if I need to. And trust me, I won't scream. I don't ever scream unless it does pinch. But you know, you come on in here because it is going to be fun story time. State court guardianships proceedings. The complainant indicates that the state court in Leon became involved in the process in 2019 and remains involved today. The complainant alleges conspiracy relied upon interaction with alleged oversight by the guardianship probate court to initiate, facilitated, blah, blah, blah. And his state court ultimately referred the entire case to the Florida bar for review. You see that? The state court ultimately referred the entire case to the Florida State Bar for review, but the court did not single out a specific attorney. Instead, the court said it fully trusted the bar inquiry into any court conduct. Then it goes into his death, which is pretty bad, and we're not going to talk about that. Probate proceedings. Complaint alleges these defendants filed fraudulent billing documents. These were hearings in state court on the amounts owed to various professionals. Parts, not all, of the state court record are included in the record case at bar. He sought fees as a healthcare surrogate. The state objected and said Kessler was just a friend. The state argued that healthcare surrogates not appointed by the court are not entitled to guardianship fees as a matter of law. The statutes do not speak to them. The state also noted the potential conflict of interest of Dr. Kessler being married to Miss Van Meter. At some point, Dr. Kessler abandoned his request for healthcare surrogate fees. Amazing. He was like, he was my friend, but, sure. Sup, Rosalind Duke? I should have asked you for an invite so I could talk with Nick, just to give him a hard time. Tell him to stop being so gay. The complaint alleges no basis to believe that this is relevant to the case at bar. The case style lists 23 defendants. The bullet point list of the defendants and allegations with citations to the Third Amendment complaint follows. All this shit. Not clear. Assisted living facility where he resided, title company that facilitated the sale of his home, purchased Victor's home. So they're going after the purchaser of the home. Hit that like. That's right. Janice Wingfield. Mr. Lips using AI to write his motions is lazy, incompetent, ridiculous, and stupid. No wonder Deuce into the ecosystem. Birds of a feather indeed together. That's right. My music is always way louder than me. Okay. I can see if I can bring up my volume a bit. Give me a second. So I want you guys to grab your microphones or your earbuds and get ready to turn them down, because I'm going to edit my mic settings and I'm going to make it a little bit louder. Okay, so I want you to be ready for it, and here we go. I've got it turned all the way up. That's as loud as I can get it. Right there. That's honestly as loud as I can get it. That is the loudest volume I've got. I hope that worked. Everyone, Shizzy's volume is perfect. Good, 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 good. Thank you very much, Janice. I appreciate you. And Shizzy, your music is way louder than you. Thank you very much, Barb. I got you. I hope that I didn't turn it up too loud. I'm sitting at 100% right now. That doesn't mean that it's perfect. It just means that it's sitting at 100%. So I think I know what the problem is. I think I know what the problem is. Give me just a second, and things are going to get a little bit funky. My volume is going to go way down, but I'm going to correct it. So don't adjust anything. And let me get this one here. I have found the problem. I'm bringing the volume up, right about there. So my volume should be much better, but not too loud. Bringing that down to 35. So that should work for you guys right there. That should be the best. Hopefully. Maybe not too loud. I may have to bring my volume down just a little bit, but that there should have helped out. Good, great. Soundboard is louder and compressor is too much. Yes, well, this should be a little bit better. Much clearer. Yeah. Now play something from my soundboard. Well, here we go.
Welcome to the shit show.
That should be much better.
Every single day.
A new flavor of fuckery, 'cause everybody sucks, you see.
And they're dumber than a bag of clots. Monday, bullshit. Tuesday, bullshit. Wednesday,
that's much better. There we go.
Stupid, ridiculous, ignorant,
there was an update.
And fuckery.
And all over again. Well, and I was hoping that I could get that down to a reasonable level, so that should be much better. Back to how it used to be. Excellent, excellent. I'm a Class Z celebrity. No, you're better than me then, because I don't even exist. Yes, you did. Yes, she interviewed Nick Rekieta. You should go check that out, guys, because that is going to be a really good. That's got to be a really good interview. I came in at the very last minute, and was like, "Ah, doggone it, she's ending." But so it goes. And of course, it talks about the Rooker-Feldman document, the probate exception to federal jurisdiction, which, some of these things don't matter. Count 1 of the Third Amendment complaint asserts a claim under federal racketeer influencing Rico. The other counts arise under state law, and there's no diversity of citizenship, so those counts are within the court's supplemental jurisdiction only. The RICO Act prohibits 4 categories of activities described in 4 sections, and they're very specific on that. In each In its single federal RICO count, the complaint attempts to assert claims under each of the 4 1962 subsections. Each subsection presents its own issues, but there are also overarching issues for all the subsections. This order addresses the overarching issues and then the subsection-specific issues. The overarching issues are whether each plaintiff in each asserted capacities qualifies as a person injured. Capacity of the complaint is a complaint asserts a claim for 3 plaintiffs. The case style lists Denisha both individually and as personal representatives. The parties section does not refer to any of the 3 plaintiffs in any other capacities, including individually. Under Florida law, a future inheritance is not a property interest. Enterprise. The element of RICO claim is an enterprise defined by any individual, partnership, cooperation, association, or other legal entity, and any union or group of individuals associated, in fact, through, although not a legal entity. And it just goes through what the RICO statutes are and what it requires for them to meet. And of course, it is completely just like a lot of RICO shit, pattern of racketeering activity, and that's just a subsection of the RICO, and that's why I'm scrolling through all this, because we're not going to go through RICO crap. Operating or managing the enterprise. Let's see. Oh, I did like this. Mr. Sketchley in the complaint allegations fall far short on the issue. Indeed, the complainant seems to suggest, at least at some points, that the other defendants were themselves hoodwinked by Dr. Kessler and Miss Van Meter. And then we're going to go through, it's all RICO shit. There are 2 ways to establish a RICO conspiracy claim. The first is showing that the defendant agreed to the overall objective of the conspiracy. The second is showing that the defendant agreed to commit 2 predicated acts. So those are 2 ways that you can establish RICO. And the entire action was not being dismissed on if the entire action was not being dismissed on shotgun pleading grounds, the federal RICO claim would be dismissed for failure to state a claim on which relief can be granted. This would leave no other independent basis of federal jurisdiction. As a matter of jurisdiction, I would decline to exercise supplemental jurisdiction over those claims. Conclusion: the Third Amendment complaint is an egregious shotgun pleading. The plaintiffs filed the pleading in that form despite a clear warning of the governing standards and the requirement to comply with them. A possible explanation is that the plaintiffs simply do not have a factual basis for their claims and thus must set them out in general, conclusatory language without clear organization, the better to mask the lack of factual basis for the claims. Well, whatever the explanation is, the plaintiffs cannot proceed in this manner. The plaintiffs could be given leave to try again, but as a matter of discretion, I choose not to do that. It seems clear that some of these defendants should not have been sued at all. It seems likely that affording the plaintiffs another opportunity to amend would increase the cost of litigation and otherwise not accomplish jack squat. Had the plaintiffs been able to allege actual facts showing a RICO violation or other basis for recovery, they should have alleged the facts in the Third Amendment complaint, and they had fair warning. So it's ordered. We're going to dismiss all of 36, 41, 52, 54, 55, 56, 62, 68, 70, and 71 granted based on those motions and on the court's own motion. The Third Amendment complaint is dismissed with prejudice as a shotgun pleading. If not for the dismissal with prejudice, on that basis, count 1 would be dismissed with prejudice for failure to state claim on which relief can be granted, and the remaining claims would be dismissed based on the discretion not to exercise supplemental jurisdiction over them. The clerk must enter judgment and close the file. And this is what the judgment is right here. The judgment resolves all claims, all parties. The case was resolved on motion to dismiss. The plaintiff's claims are dismissed with prejudice against the defendants who are named in the Third Amendment complaint, all of those people. And the claims against defendants who were named in earlier versions of the complaint, but not named in the third amended complaint, were abandoned. So the claims against those defendants are dismissed without prejudice. So they could file again on those people if they so desired, but their chances are it's not going to happen. And we're going to get into a nice little letter. You're welcome to join me, Yamaha, if you feel that you got that need, the need for speed, because it's going to come up really fast.
It is about time. Let's break this mother down. With Shizzywhiznut.
An open letter to whoever pressed send on that Rico fantasy. Dear litigant of the artificially enhanced complaint, congratulations, you did it. You turned a kitchen junk drawer of legal jargon and generalized grievances into what I can only assume is a cry for help. Help from someone who understands the federal rules of civil procedure, predicate acts, or reality. I slogged through your Rico case set statement, all 10 pages. Every copied statute, every circular accusation, every this happened before Rico, and I'll be honest, somewhere around your fourth mention of 18 U.S.C. 1961, I wasn't sure whether I was reading a lawsuit or watching someone argue with a microwave. Let's start with the foundation or lack thereof. You allege the existence of an enterprise. Bold! But, Instead of building an enterprise with facts, dates, and actions, you started naming people like you're rolling credits on a true crime podcast. Judges, lawyers, hospitals, clerks, no connections, no roles, just good vibes, man. The only Rico pattern I see is that every time someone annoyed you, they got added to the list. And then come the crimes: mail fraud, wire fraud, extortion, bribery, tampering, the full buffet. You basically opened the federal code and said, yes. Dumped it into the complaint like it was seasoning remix. Never mind that you don't explain who did what, when it happened, or how it relates to a goddamn thing. You just asserted it as if invoking a statute automatically proves it happened. Well, spoiler, dumbass, it doesn't. This is not how Rico works. This is not how lawsuits works. This is how Reddit threads spiral. You've got pages dedicated to grand sweeping claims about systematic abuse, corruption, silencing, yet not a single concrete, verifiable, legally actionable example of racketeering behavior used under the color of law like it's punctuation. You say pattern activity like you're ordering one off of a menu. You cite injuries like an emotional trauma, and reputational damage as if the federal court is your therapist. You're not alleging racketeering, you're performing it in reverse, weaponizing the court docket for your own cinematic arc, hoping that if you throw enough legalese at the wall, something will stick and someone will settle. But we both know what this really is. You wanted to scare someone or embarrass them or go viral. You wanted the illusion of power, the performance of consequence. You're not prosecuting a criminal enterprise. You're pretending to be the one thing you never bothered to become: credible. Let's not ignore the obvious. This was written in whole or in part by generative AI. Don't worry, you're not alone. Hallucinated case law is practically its own genre now, but this filing, it reeks of autocomplete. The formatting, the phrasing, the sterile stat, heavy copy paste, cascade with zero human pacing. Well, that's not litigation. That's Mad Libs for disbarment there. Judge isn't going to hear your truth. They're going to read it, side, schedule, Rule 11, show cause hearing fast, and you can say, chatbot. So before you file the next Rico remix, maybe take a step back. Ask yourself, is this legal strategy, or am I just upset and bored with Pacer login? Because this isn't accountability. This isn't justice. It's just cosplay, and not the fun kind. And just like that, the clang goes the gavel, and all your AI-generated vengeance evaporated into federal ether. Let's not talk about what just dropped from the Northern District of Florida on June 25th, 2025. The clerk of the court, with the same energy one uses to swat away a fruit fly, entered that judgment dismissing your entire fantasy camp litigation with prejudice. That means it's over. You don't get a sequel. You don't even get syndication. You named every building, business, physician, facility, and dry erase marker east of the Swanee River, only for the judge to casually boot every single defendant into legal oblivion. The rest, the poor souls you dropped between drafts like a bad subplot, were dismissed without prejudice, not because the court cared, but because you apparently forgot they even fucking existed. That's how disposable your conspiracy was. Let's be clear, this wasn't a close call. This wasn't a gosh, you almost had a moment. This was legal mercy killing. The court didn't just rule against you after hearing compelling arguments they never had to. This entire production was dismissed on motions to dismiss. Judge never even had to entertain the idea that your complaint was describing reality, because it didn't. What it described loosely was a Google search, a courtroom fantasy in a world where anyone who didn't hand over your preferred guardianship order must be part of a racketeering cartel. And that's not a lawsuit. That's the script of a daytime courtroom drama written during a Red Bull blackout. And look, I get it. Filing federal lawsuits make you feel powerful. It gives you control, even if it's just on paper. But, you know, paper burns fast. In your case, court didn't even bother lighting a match. They just opened a window and let the wind of Rule 12b-6 carry it away. So now what? You're out the filing fee. Your complaint is DOA. The judgment is stamped, filed, and probably framed in the back office somewhere as a cautionary tale for summer interns. But the worst part, you're going to tell people that this was part of the plan, that they never let the truth come out. That this proves just how deep the conspiracy really goes. Meanwhile, anyone with Pacer access knows exactly what this proves. It proves that you brought a Rico case to a court of law without bringing a single legally sufficient fact. And you didn't just lose. No. You made losing look easy. You made dismissed with prejudice feel like a gift. Me? I'm just a guy in Velcro shoes sitting in front of a camera watching federal fantasy LARPers burn their own credibility like it's performance art. So keep filing. I need the content. With mild concerns for your Pacer bill and the overwhelming gratitude for your commitment to bad decisions, Shizzywhiznut. Still wearing Velcro shoes, still riding the short bus, still outperforming your AI lawyer with used coffee filter and a broken sarcasm switch. And most definitely owning your ass on this shit.
It is about time. Let's break this mother down. With Shizzywhiznut.
Oh my. You have no idea. I've got a beautiful story for you guys. I'm going to wait and see if Yamaha comes here, but I will give you a little background on this, okay? Because apparently last night the flea showed up on a little stream. She had so much to say. And so many things that she was telling everybody that she's going to go over. Well, and the beauty is you don't have to worry about going over it, because I have a nice little tale. It's a beautiful tale. It's an untitled story. And yeah, I mean, you guys need to keep cheering for him. Make him want to come in here. Paging Yamaha, Shizzy need you. I know. This story is a good one. It is an absolute banger of a story. It'll probably take a good 30 minutes just to get through this story, because it is fire. It is fire. Oh my God. Oh my gosh. It is, and it is a satirical story. It's a very satirical one. So, Beijing Mr. Yamaha, leave that Suzuki alone. Well, you know, what would a Yamaha do without humping a Suzuki? I mean, Just saying. What exactly would they do? Oh my gosh. And tomorrow morning, I'm going to be on with Mo. It's going to be glorious. I'm going to be over at Mo's in the morning. And then tomorrow night, be back over here for like a little, what do you call it that? Foreplay before Friday FNL on the experts. That you don't want to miss, because that's going to be a fun night. Beep, bin. Police. They're like, pretty please, come on, Yama. And well, he might have lost power. He might be in the middle of a snowstorm. You never know. You know, that's that North Pole gets those nips and he can't handle it sometimes. But of course, what they were saying was there was this little thing going on that they had a very interesting take on all that was happening, and they were going to make a big announcement over this letter or some crap that was being sent to shock it. And they were sending it right away. Oh my gosh. Yes, it was going to be glorious. It was going to be beautiful. Oh my gosh. What do we have here? We've got something that's even more glorious. Ladies, put your panties back on. Hello, brother.
Hey, what's going on, everybody? I was waiting to hear you scream at me like you do when I'm mid-grunt on your front porch. And I just didn't hear it.
No, my
right
wife
before that shotgun blast.
my wife would have lost it, and I done that. Says, love listening to your show, Shizzies. The letters are brilliant. Well,
Welcome to the shit show.
that's all I got to say about that. And I did
Hello,
have some
everybody.
fresh stickers. Where did they? Ah, there they are. I hid them for myself because I was getting over exuberant with them and sticking them all over everything, especially like on my forehead. It was getting annoying. Let me see. Let me get that foot right there. Ah, yes, that one's for you. Thank you very much. I appreciate you very much, Colleen. That'll definitely keep this channel going. And this story is beautiful. I spent a little time with it. You're gonna love this, and you could read parts of it. It's literally 3 chapters long, so don't feel that you have to read the whole thing. You just take your time with it. There won't even be any music.
Oh, okay.
Well, I mean, I could do the music, but it's going to have to be really, really low.
Yeah.
Like this.
We can turn it way down. That's fine. Yeah.
Yeah.
Yeah, just a nice little ambiance.
Yes.
Yeah, we could break that up. That's fine.
Yes.
All right. Well, here we go. Chapter 1. When you represent yourself, don't bring a mirror. There are bad ideas. There are catastrophically bad ideas. And then there's deciding your husband should represent you in a court while you LARP as a bar whistleblower from your couch in a bathrobe that hasn't seen soap since the Bush administration.
I know, that was pretty good, wasn't it?
That's a good one. Cheeto stains, bonbon stains.
Lipstick stains.
Yeah, right. She wasn't alone, of course. In the curious pairing of ego and enabling, her husband, a licensed attorney in his own right, had decided he would represent them both in court, himself and her, the defendant and the fallen former attorney, who now communicated mostly in half-truths and text message novels to YouTubers. Together, they formed a legal team that might have been powerful enough in another universe. Perhaps one where civil procedure is crowdsourced and depositions are done via live stream over frozen soup. On the floor, 3 empty Red Bull cans, a chewed pen, and the printed remains of a lawsuit so delusional, even the paper looks ashamed. Center stage, Lipschitz, formerly an attorney, now a self-appointed martyr on a mission to save the world from facts, consequences, and, most of all, Jeremy Hales. Well, she used to post. Boy, did she post. Facebook diatribes, YouTube clips, Facebook sock puppet accounts, Instagram stories with legal takes that made 4chan blush. But now, gone. All of it. Wiped. Vanished into the same ether where her credibility lives. No explanation. No warning. Just digital vapor trails and the distant whimper of her narrative gasping for breath. Still, oh, she's not silent. Oh no. She's just outsourced her delusion. Enter Fleesa, the gap-toothed gatekeeper of garage gossip and one-woman disinformation hub for the anti-what-the-hells ecosystem.
What is your favorite color? What is the speed velocity of a swallow?
All cockeyed and drooling, with her little cane and broken jibs. Lipschitz doesn't post anymore. She passes a note like it's homeroom, and Fleesa, ever the loyal ventriloquist dummy with a vape pen, repeats them verbatim, just enough cigarette haze to obscure the source. Well, to the outside world, this might have seemed like a bold choice, but the reality was simpler and sadder. No one else would tell her story. Not after the way the first lawsuit went, not after the filings, not after the dismissal, and certainly not after it became clear that the litigation strategy wasn't to win on the merits, but to cry harassment, and anytime someone asked to see the evidence. According to sources close to the situation...
No, you got it wrong. The voice isn't right.
Yeah, okay. According to sources close to the situation. Fleesa breathes into a barely functional Logitech mic. Bar complaints. Where the fuck did that one come from? Bar complaints have been filed. Oh, they're real. And Michael's helping. He's an attorney, you know. So it's serial. Yes, Michael, the husband, MFer, by the by. The only man alive who could manage to look smug while accidentally stapling emotion to his forehead. A man so competent, he thought it was legally sound to represent himself and his wife, while also playing both victim and lawyer on the public record. He speaks at hearings like he's auditioning for a reboot of The Practice, but keeps getting out-argued by documents he himself submitted. Keep aiming high and somehow shooting yourself in the foot. It was his idea, allegedly, to double down on strategy by filing Florida bar complaints against plaintiff's counsel. Because when you're boxed in by sworn statements, evidence, and the undeniable stink of your own frivolous lawsuit, the obvious move is to call the ethics police on the guy beating you in court. Here's the twist. No one knows if the complaints were actually filed. Well, that's the genius of Lipschit's scheme. She mastered the art of narrative without paperwork. She tells Fleesa, "It's been filed." Fleesa tells the internet, "It's official." And suddenly, the garage streamers are celebrating a fantasy like it's a court order. Meanwhile, no one sees... Wait a minute. Meanwhile, no one's seen a timestamp. No complaint number exists. And the bar is sitting somewhere in Tallahassee wondering why a gaggle of unwashed YouTubers keeps referencing documents they've never received. Because long before the courtroom, long before the filings, long before the inevitable motions to dismiss, there was a simpler mission. Silence the people talking. Lipschit's lawsuit, in all its fragile glory, was not born out of a desire to correct the record. It was born out of fury that anyone had dared to speak at all. She didn't just sue for defamation. She sued for breathing. And that's rich, coming from someone that I assume has to remind themselves to take a breath every 3 to 5 seconds. And that's a talent that not everyone has. For opinions! For sharing documents already in the public domain. The complaint reads less like a statement of claims and more like a personal burn book, organized perceived betrayals and time-stamped live streams. No, she tried to spin it into something noble, something righteous, a stand for truth, if you will. A mother's protection, a mother's warning. And with enemies like that, who needs a mother? But buried beneath the lofty claims of reputational harm were the real goals. Shut down the coverage, discredit the critics, and above all, reframe herself not as a liability in someone else's case, but as the victim of it. And when that didn't work, when the world didn't flinch, and the pressure started to mount, and the discovery requests grew closer, she dropped the whole thing, quietly, strategically, merely to docs. Not because her claims were resolved, but because they were rotting. No, she didn't want answers. She wanted silence. And when she couldn't get it through courts, she turned to the only place where silence doesn't matter, and proof is optional. YouTube. But we're getting ahead of ourselves. Back in court, Michael still had to keep the act going, still had to file and argue and pretend that every motion to be dismissed was just a technical delay. He submitted filings with the zeal of a man who truly believed that if you string together enough indignation and citations from unrelated cases, well, eventually someone will believe you. And Lipschitz, well, she stayed in the shadows, like the nasty, bedraggled, makeup-smeared vampire she is. Gone were the daily posts, the threads, the not-so-subtle dog whistles. Her accounts were deleted. Her history vanished. Her claims dissolved like sugar in warm tea. But that doesn't matter to Lipschitz. To her, facts are for the small-minded. What matters is the story, the arc, the victimhood cosplay. Well, she can't admit she filed a lawsuit based on fiction and had to dismiss it before the hearing even started.
No.
Whoa, no. She can't admit Randy Shaka keeps handing her and her husband his procedural lunch in every filing. So instead, she becomes the shadow. And only the shadow knows. Whispering accusations, feeding Fleesa half-truths and whole lies. And like everything else she shovels into her gaping maw, just gobbles it down. And scrubbing her presence from the internet like she's in witness protection. The bar complaint? Maybe real. Maybe not. What's real is the internet, or the intent. The internet. I was going to say, wait a minute, that's fucked up, dude.
Yeah.
The internet, yeah. What's real is the intent, not justice, not ethics, revenge. Delivered secondhand, wrapped in paranoia, and tossed to the internet like a bag of shit or expired rice. And the husband, still pretending this is all going according to plan, still signing pleadings that contradict themselves in consecutive paragraphs, still grinning like a man who just discovered Adobe Acrobat but hasn't figured out how to save. Or a little boy playing with this thingy when he just figures out it gets hard. They wanted to file complaints to intimidate. What they filed instead was a new chapter in the growing anthology of how not to practice law while under the impression that live streams equal legitimacy.
Chapter 2, the fleas go public with fiction, or when lawsuits fail, just live streams the lies. Some people appeal after their lawsuits fails. Others regroup, re-strategize, consult real attorneys, and prepare to come back with stronger claims in a tighter case. When news broke that bar complaints had been filed, the legal world did not gasp. The Florida bar didn't issue a press release. The court didn't slam its gavel in reverence. The public didn't chant, lip shits, lip shits, lip shits. No, the only ones who reacted like it was a seismic event were the fleas, a crew of live streaming legal illiterates who treat gossip as gospel and microphones as megaphones for their own insecurities. And then there's lip shits who, upon voluntarily dismissing her flimsy suit with all the grace of a buffet fight at a Golden Corral, decided to pursue a much nobler, more dignified path, whispering unverified nonsense into the ears of people who couldn't define jurisdiction if you tattooed it on their forearms. Do you like that, Golden Corral?
Yeah. The buffet brawl.
They took the claim. Lipschitz
This one
filed
makes
a
the
complaint.
OK Corral look like a child's walk. Coming to a theater near you.
George, so close. They took the claim. Lipschitz filed a complaint and sprinted like it was the last blunt at a middle school sleepover. Within hours, the internet was ablaze with celebratory screeching. She did it. Gar complaint incoming. That liar's dead. The streams that followed weren't just reactions, they were rituals. Oh, they were lit with that soft glow of bug-filled lights and desperation. A new figure emerged. Not new, really. She'd been there all along, lurking in her garage like a creature summoned by bad lighting and expired nicotine. Fleesa appeared like a prophet in front of a microphone duct taped to a dirty ashtray. She squinted at the screen, exhaled plumes of mentholated hubris, and declared with breathless authority, "The Florida bar's involved now. This is serious, y'all. These are just live stream wars. This is legal accountability." Legal accountability, according to Fleas, is a magical event that occurs when one of their own says something serious sounding into a microphone. No evidence required, no public record, just vibes, cigarette ash, and secondhand screenshots. She streams nightly from the Villages, Florida, a place known more for its loofah-coated golf cart orgies and HOA infighting than constitutional law. Her streams are faceless, breathy, and built around the same three ingredients: unfiltered cigarettes, processed snacks, and blind loyalty to anyone willing to let her break the story without asking for proof. Fleesa's signature style isn't subtle. You hear her before you even figure out what the topic is. There's always a rustling bag, a shallow cough, and the sound of some poor headset.
Like a cow chewing cud. If you hear a cow chewing cud, it's probably Fleesa.
And the sound of some poor headset fighting for its life against the humidity and whatever she just inhaled. She speaks in broken sentences with chewed syllables, reading aloud screenshots like she's narrating the book of Revelation with extra butter and a side of grievance. According to what I was told, Lips filed the bar complaint. Michael helped draft it. It's been sent to the bar. We got him now, y'all. Chat loses its collective mind. See, that's a wife, Mom. This is what accountability looks like. Never mind, no one has seen the complaint. No one has confirmed it. There's no timestamp, no scan, no record. Just the word of a woman who once claimed to have exclusive intel from a voicemail she recorded by holding her phone up to the speaker and coughing into it mid-sentence. Well, Fleesa doesn't question it. She doesn't have to. Her job isn't journalism, it's delivery. She is Lipschit's last working speaker system, and tonight's sermon is vengeance. And what exactly is she reading aloud? Nothing more than the corpse of Lipschit's original lawsuit, now reheated and rebranded as an ethics complaint. Same accusations, same imagined slights, only this time instead of aiming at its critics online, she's gunning for opposing counsel. The same one who dismantled her in court and walked away with procedural win and a stack of receipts. Of course, you won't hear that part in Fleesa's stream. What you'll hear is the revisionist myth that this was never about silencing speech or controlling the narrative. No. It's about protecting her children, because that's the new headline, crafted not for the court, but for the comment section. They threatened her and her kids. That's why she had to act. Except no one did. No one threatened Lipschitz. No one targeted her children. No one even cared where she lived until she started filing lawsuits and tagging people in every post like it was her side hustle. But now suddenly, this is the tale. She wasn't trying to chill speech or punish dissent. She was fighting for her family. The bar complaint, we're told, is the only option she had left, not because the court rejected her claims, not because the lawsuit fell apart, not because the facts just didn't line up, but because she had to protect her babies from the mean live streamers. It's fiction, brazen fiction, but it's being swallowed whole by an audience trained to never read past the caption.
The voices are my babies.
And in the garage lit only by a dim light and a dim glow of bad decisions, Fleesa plows forward. This ain't over. Y'all think they're just winning just because we won that suit? Nah, this is chest, and Lipschitz just made her move. No, she didn't. She replayed a losing move and gave it a new label. And that's not chess, that's Connect 4 with missing pieces and a bag of Cheetos stuck to the board. But Fleesa can't tell the difference to them. The bar is a courtroom, the live stream is a deposition, the text message from Lipschitz is gospel, and the only thing more satisfying than making things up is getting away with it in front of an audience that won't ask questions. What they don't realize is every single stream is evidence, every smug laugh, every "we got him," every repurposed lie. It's all time-stamped, archived, circling back towards the docket, though they thought they escaped. It's because while Fleesa babbles about crystals and hero moms and whispered conspiracies, somewhere a real attorney is drafting a real response. Not to what was said in court, but to what's being performed online in its place. And just like that, what began as a dismissed lawsuit has now metastasized into a secondhand ethics tantrum. Delivered anonymously, broadcast relentlessly, and destined to implode on impact. But here's one problem. When you broadcast retaliatory bar complaint mid-litigation and make it part of your show, you're not just a clown. You're a clown confessing to motive. Because now the world sees the playbook. Not justice, not ethics, not even concern, just rage and narrative control. They don't really care if it's real. They care if it trends. Fleesa had the gall to suggest the complaint would strip opposing counsel of their license. Yes, because nothing impresses the Florida bar more than filing a complaint out of spite while being sued. Broadcasting your intent across streams named things like "what the cricket hails" and confusing "I lost in court" with "my opponent must be punished." It wasn't just unwise. It was textbook abusive process. proudly live streamed to an audience of 47 sock accounts and one woman who thought she was attending a book club. And let's not forget the others, the backup fleas, the ones who chimed in to say, "This is what a real accountability looks like." These are the same people who think hearsay is admissible if it's told to you in a DM. The same crew who believe that filing a complaint means someone's career is already over, as if the bar doesn't toss out frivolous vendettas on a daily like expired coupons at Publix. By the end of the stream, they were high-fiving each other's words like bombshell and karma, all while admitting they hadn't actually even read the complaint. Well, fuck, why would they?
Yeah.
Reading it would just confirm that it was either never filed or lifted directly from hallucinated claims of lips dismissed lawsuit, which, by the way, also made its debut in a cloud of smoke and promptly got vaporized. So there they sat, basking in the glow of a win that never happened, declaring victory in a war no one else recognized, celebrating the filings of a document no one can verify while completely ignoring the part where the bar doesn't issue verdicts on YouTube time slots. But that's always been the flea brand. If you can't win in court, stream it into existence. Chapter 3.
Chapter 3. Bar None of It Matters. Or when the complaint hits the clerk's desk and immediately gets buried in a stack of real problems. In the imaginations of Fleesa and the flea hive, the bar complaint detonated like a procedural nuke. They pictured it. Alarm bells ringing, suits scrambling, Randy to spar before lunch. Or brunch, whatever. In their fantasy, the Florida bar was an emotional support tribunal ready to leap into action based on anonymous streams and a handful of allegations yanked from a voluntarily dismissed lawsuit. A lawsuit so thin it couldn't survive its own narrative structure. A lawsuit that was never meant to be proven, only posted. But here in the real world, the complaint, if it exists, was likely reviewed by a mildly annoyed staff attorney named Tina, who read it between two legitimate grievances, rolled her eyes, and dropped it into the retaliatory trash fire file alongside such classics as, "I lost the motion and now my feelings are hurt.
My neighbor is a witch and possibly a lawyer.
And he made fun of me on YouTube." The bar, oh bless him, has seen it all before, and they know the difference between misconduct and butthurt cosplay dressed in Times New Roman. Meanwhile, Fleesa kept the campaign alive. Imagine that thing jumping on you and giving you CPR. Even as the initial high faded and no lightning bolt struck Randy from the clouds, she pushed the narrative like a hostage reading cue cards under a ring light. Just because they haven't seen the outcome doesn't mean it's not happening. She wheezed in a follow-up stream between puffs and half-chewed cookies.
Well, sometimes they don't respond because it's ongoing, confidential, you know.
Why am I sounding Australian now? I can't do that voice anymore. You know, it's official bar stuff. My New York turns to Australian. That's fucked up. Sure, that's it. I can't control the voices in my head sometimes. Totally not because it was tossed in under 5 minutes as baseless and possibly unhinged. No, definitely a secret tribunal that only communicates through DMs and garage streams. Meanwhile, Lipschitz has transitioned to her next phase, telling everyone that filing the complaint was a sacred act of protection, and that this was bigger than the case. She was now whispering about constitutional violations and hinting that the federal government might get involved right after she figured out how to redact PDFs correctly. Still hiding behind proxies. But still, weaponizing implications while avoiding litigation. She doesn't really need to speak. She's built an entire ecosystem of enablers, willing to mosquito her into martyrdom.
Misquote.
Wow, mosquito her. What the fuck was that? Misquote her into martyrdom. Mosquitoed? Well, they are a bunch of little bloodsuckers. They are a bunch of little bloodsuckers, so it doesn't make sense. All right, misquote her into martyrdom. See, this is why when I read my stories, I have to do so many damn takes. Let them, yeah, let them, yeah. All the cold reads aren't glorious. Let them stream the spin while she plays the wounded sage in private. The Fleesa remain convinced this is a long game. They say, "You'll get hit." They nod solemnly when Fleesa says, "Justice takes time," ignoring that it's not just justice they're waiting on. It's a storyline with no third act. But here's the truth they won't say out loud. This complaint wasn't a legal strategy. It was a consolation prize for losing the lawsuit. It wasn't meant to succeed. It was meant to trend. To control a narrative they no longer had the facts to win in court. To send a message. If we can't beat you legally, we'll bury you ethically. Or I'll just sit on you in public. And while the bar quietly forgets their tantrum, their tantrum ever hit the box, the court watches and waits. Because what the fleas forget is that when you make your defense public, you make it admissible. And when you scream retaliation into a microphone, you're not just venting, you're documenting motive. Back on the flea stream, things got quieter. The bar complaint was supposed to end everything. It hadn't even triggered a response. Fleesa coughed into the mic and changed the subject. The chat went dead. And somewhere in Florida, the bar investigator clicked closed. No probable cause. And wondered why the lunatics always email at 2:47 a.m. So now we wait. Because maybe Fleesa has one more stream in her. Maybe Michael has one more filing up his sleeve. Maybe Lips, boxed in, out of options, tries again. New venue, new excuse, new lie. Or maybe, just maybe, they all realize the one thing they feared most. No one believes them anymore. Not the bar, not the court, not even their own chat. But if they don't come back, if they try another round, another filing, another anonymous crusade, well, we'll be there, with loofahs in hand, receipts and folders, and snacks of our own. To be continued? We'll have to wait and see. Oh my God.
Yeah, I have to eat the table or I hurl. It really makes me sick even without seeing it. Yuck.
What? Yeah. Well, like I said, when you shove those clips, or when somebody else does, you see those clips, and it's just like, oh my God. And then you have to wonder, how the fucking people sit there and listen to those idiots for 8 hours?
Well,
apparently they've been on this 8-hour kick, I guess.
But see, that's the funny thing about it is they believe that filing a bar complaint against Randy is like the best thing that they could possibly do in the whole wide world. Like, this is going to change everything.
Yeah.
You have no idea. She's adding all the documents. She's got 97 pages or some shit like that of a bar complaint and documents to back all of this complaints up.
Yeah.
And, you know, initially...
Yeah, and I guarantee you that's what they're doing. They're just sitting there with their hands, their head in their hands, shaking their head, going, what the fuck? And it's going to get round filed. It's not going to mean anything.
Yeah, but it's for content. But,
Right.
See, just all you have to do is listen to what they accuse others of, and it shows what their plans are and what they're doing.
Yeah.
It's
They are what they claim to hate and stand against. That's exactly what they're doing. They're doing,
You never know where that loofah has been.
Yeah, right?
Okay.
Yeah. Can you imagine that? That nasty, moldy, fermented cheese-filled, nasty little thing. Holy shit.
It's got bits of skin in it, or at least that's what you think it is. Oh, that's so bad. Oh.
Oh, you're welcome, Melissa McDonald.
Well,
Glad you enjoyed
that's completely different. That's filing it against somebody that's doing what's called APL. It's part of the bar, but it's for people that are practicing law without a license. That's what that is. That's completely different. And it wasn't an actual complaint. It was just here is the notification of what somebody's doing. There's a big difference, and it was probably pretty short, so they can look at it themselves. I haven't seen it. That's why I never really talked about it, is because I mean, he's got something that he filed, but I haven't seen it. You know, it's what does it matter to me? It matters not to me. Just like all of this stuff does it. I find it humorous. I find all of this like it should be mocked endlessly.
Yeah,
just can't help it.
Exactly.
And that's why I wrote an open letter, because I was like, there's nothing like a glorious open letter. So make sure you've got to, gargle a little bit of the water and get ready for this one, because it's going to be good. Yes, it's good to see you, Max. Shizzy, also Jeremy, tonight on Megan's Live, Jeremy said Fleece 1 would be served for Ohio court. Oh, that's a big possibility. That's a big possibility. If things were filed in Ohio court and she had anything to do with it, then that's what happens. And also you still have the bankruptcy, which that stuff's going to be coming up really damn soon.
Yeah.
They're going to have a nice little meeting of all the creditors. So, and then the trustee gets involved. That right there is going to be interesting in itself. And then there's other filings and pleadings that are happening. One of them that I've been following and I've talked to you guys about. There's supposed to be some resolution coming up really soon, and whenever that comes up, that's going to be really good. This particular one, all I can say is it is going to be therapy. It's going to be therapy, and I can't wait to read the outcome of it, because it is going to be good. You think that's tomorrow? Well, it could be. I mean, I don't go searching for a lot of this stuff, and here's the thing, Lisa read something online. Someone showed me a copy of what she was reading. Like it was some big breakout thing of this, motion that was going to be filed unless you did X, Y, or Z. Oh, very cool. Very cool. I will check that out. And I was like, okay, well, so we got that. And then, of course, you know, apparently Tug and Megan, because they're part of the lawsuit, are like, well, this would be our filing if he files that. Never has been filed in the court. I mean, once it gets filed in the court, I didn't even bother taking screenshots of it. I was like, that's their story, and it'll be interesting to see what actually gets filed and what doesn't get filed. It's just, he made the case for me. Oh
yeah. Janice Wingfield is asking. No, Shizzy made that opening for me. He made it for me and Ballstorm and Diva and so and Welsh Lady Reed. So that went way back with our story stuff, and then that way whoever comes up.
Yeah. See, like you've got this one, which is Volstorms. I could show that one. I've got the experts. The experts is short. This is the experts.
How are you today, sir? Okay, how's it going? Fine, thank you. Thank you, sir.
It tells me every single time. If you know, you know. Oh my God.
Yeah, yeah. That one goes back a while. Yeah, you kind of have to know that.
I even have one for the broken bacon.
Captain.
My muscles are getting bigger. Oh, yes, the muscles. The muscles are getting big from the pump.
Yeah, I like that one.
I love that one. Oh, that's so fun.
Yeah.
So much fun. I've got one for MG. I've got one for Danielle. I mean, I've got tons of them. I enjoy every single one of them. But before we do anything else, we got to get to that open letter.
It is about time. Let's break this mother down. With Shizzywhiznut.
Helmet on, ready to go.
Oh, yeah.
Open letter to the people who think a bar complaint is a winning strategy. To the anonymous crusaders of internet court and the flea adjacent mouthpieces who yell into voidy garages for validation. Let me start by offering my sincerest congratulations. Okay. It's been an absolute delight watching a dismissed lawsuit get dragged out of the digital gutter, rebranded as a bar complaint, and then handed off to a chain-smoking avatar like it's a classified document and not the procedural equivalent of a wet paper towel. It takes a very special kind of stupid to lose a lawsuit so badly that you have to delete your entire online existence, and then, instead of learning from the spectacular self-immolation, you decide to repackage the same lies and dump them on the Florida bar's desk like it's the plot twist that will finally redeem your crumbling fanfiction arc. You were mad someone reported on you, laughed at you, read your filings out loud, or simply said, "This is fucking nuts." And instead of answering the criticism, you tried to nuke it. In court. Really? Oh, golf clap. Bravo. This isn't just petty. It's Special Olympic level petty. It's, I trained for years with a coach named Defamation doesn't mean what you think it means. And it still managed to trip over my own ego at the starting line. Levels of petty. The kind of petty that gets statues built out of restraining orders and broken NDAs. Let's rewind for the audience at home. You filed a lawsuit. Correction. You flopped a lawsuit that was allegedly about defamation, but was transparently a shotgun blast aimed at anyone who dared to repeat what was already in court records, public filings, or, God forbid, react to your behavior. The moment anyone accurately quoted you, questioned your motives, or even looked at you too hard in a thumbnail, you screamed, "Slander!" and threw a hissy fit wrapped in Times New Roman. You filed claims so fragile they crumbled before they reached a hearing, and when you realized the only thing you were proving was your own instability, you quietly hit eject, and then ran to the nearest whisper chamber to cry, "They're threatening me and my kids." No one bought it. No one ever threatened your children. That fantasy was manufactured from paperwork collapsed, and you needed something to justify the fact that you voluntarily dismissed your own narrative. But now, with your credibility 6 feet under, and your lawsuit stripped for parts, like a horrible little Barbie doll, you've decided to reinvent the same garbage as a bar complaint. Not because it's valid, not because it's new, but because you need to feel like you're still in control of a story you can't keep straight. That's what happens when you lie over and over again. And when you realize that people are not buying it, when discovery crept closer and those Facebook posts started looking a little too real, you quietly tucked tail and dismissed the entire thing. No ruling, no hearing, no apology, just poof. Like the whole disaster had filed itself out of existence, or your failed attempt at a Harry Potter movie. Now, a normal person, having just exited a lawsuit they fabricated from Reddit threads and nicotine-fueled paranoia, might lie low, reflect, regroup, possibly Google what burden of proof actually means. Oh, but not you. No. You decide to take the very same made-up claims that got you laughed out of your own pleadings and repackage them like stale leftovers reheated in a Tupperware of spite and mailed into the Florida bar like it was Santa Claus and you were the saddest kid at the grievance mall. Except you didn't even have the nerve to do it yourself. You outsourced the whole performance to a chain-smoking avatar with a snack addiction who now functions as your official press secretary, broadcasting every manic whisper you typed into her inbox like it's the Dead Sea Scrolls, and not just recycled accusations from your failed legal tantrum. You really thought this was a power move, using a coughing sock puppet in the villages to publicly announce a bar complaint that nobody's seen, nobody's verified, and nobody outside your cartoon avatar or the voices in your head even believe exists. You passed it off like contraband in a prison yard. I'll bet that prison wallet's just stuffed. Full of all kinds of shit. That's why Paint Chips likes her so much, probably. He likes them prison wallets. Whispered through texts, recycled by people too stupid to ask for proof, and broadcast by someone who confuses litigation with a topping for pizza. Oh. This looks like a Picasso masterpiece. I'm so confused. She never shows her face, but boy, does she show her ass! Every time she lights a cigarette and chews her next sentence into the mic like a court exhibit, like it's a court exhibit, she gives away exactly what that is. A tantrum with a headset, a spite parade, a bedtime story for people allergic to facts and high-functioning reasoning. You want to accuse someone of misconduct? Try doing it without using an unpaid middleman who treats every live stream like an open mic night for the legally challenged. Let me explain how this looks to the rest of us. You launched a lawsuit to silence your critics. You got caught. You ran. And now you're trying to punish the guy who called your bluff. Not with evidence, not with proof, but with a sad little ethics complaint wrapped in half-truths and delivered via geriatric live stream. And the bar. If they've even received your masterpiece, and that's a big if. Since all evidence of your claims comes from someone who breathes like she's battling a Pringles can in every sentence.
I gotta get that last crumb.
Licking the sides and everything. Breaking it open. Then it's likely already been routed to the retaliation from litigants who got smoked in court bin. Right between the guy who tried to disbar his divorce attorney because she was mean and the lady who filed a complaint against a judge because, well, he didn't like her aura. So now what? Do you spin this too? Do you say the bar is in on it? Do you go back on stream and say, they're just dragging their feet? While your favorite voice actor continues chain-smoking your latest hallucination into a discount microphone? Or do you just quietly wait for the stunt to backfire again? When the courts, or a real journalist, or the very attorney you're targeting, points out, with receipts and filings and actual grown-up logic, that all you've really done is create another trail of motive, malice, and manipulation. See, here's the thing about playing games with professional complaints. If your story collapses the moment you asked for evidence, if your narrative keeps changing to fit whatever audience you think will believe you, if you keep launching attacks and hiding behind people with avatars and snack drawers, then maybe you're not the fucking victim. Maybe you're just the common denominator. And every time you recycled your nonsense for new venue, you make it that much easier to show that this was never about truth. It was about control. About owning the conversation. About taking your frustrations on the people who wouldn't let you lie. I'll be waiting, right here, for whatever desperate sequel you try next. You call it justice. Well, we call it Exhibit B. With all due sarcasm and the world's slowest short bus parked proudly out front, I remain the artard with a keyboard, Velcro shoes, and a courtroom snack tray of receipts. And I will never be your fucking daddy, Shizzywhiznut.
It is about time. Let's break this mother down. With Shizzywhiznut.
And there you go. Can I do a fun show or what?
Yeah, that was good. That was fun.
Oh, gosh. Again, guys.
And that's the funny thing. We get to laugh. We get to have fun with it. And it drives him fucking nuts. Oh, they're laughing at all my feelings.
They don't realize it's all
They don't fucking
satire.
care about your goddamn feelings. They don't care.
And it says, M's Fire says, the man, the myth, the legend, Yamaha, well...
Welcome to the shit show.
Yes, every single day A new flavor of thuggery, 'cause everybody sucks, you see, and they're dumber than a bag of twats. Monday, Tuesday, Wednesday. There we go. Ignorant, balderdash, poppycock, bollocks, and thuggery. Oh, yes. And Emma, beautiful, says, I am still here. Time for the letter. Thank you. Thank you so much for being here, Emma. And thank you all for being here.
Yeah.
It is a wonderful pleasure. Thank you,
it's always
Yamaha,
fun
for
when you
coming by.
Oh, thanks for having me, man.
Oh, man, it's great having you on here. And also, just you guys know, tomorrow morning, be live with Mo, where we do our Friday mornings. It's a free for all, and we'll probably be looking at some mug shots. Who knows? And then, of course, Friday night, you guys get to come over here right before FNL. We'll probably be doing something really ridiculous and stupid. I can guarantee you it'll be me, Mo, maybe Yamaha if he wants to come by. We're just going to be stupid and probably watch like ridiculous stuff happen in real time. Maybe watch some like Twitter fails or some crap like that. You never know. We do all kinds of crazy stuff. Everybody have a wonderful night.
Everybody.
And I'll be sending you guys somewhere. I don't know where yet, but you'll be going somewhere, and it won't be to hell because you guys are too good for that. Peace, guys.
Oh, you thought I was done, bless your heart, but I'm still living rent-free, it's a work of art. Call me daddy, call me nut, call me the goat. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen, caught up in my glow while you stay unseen. Your shade's like a breeze, it's barely a draft. Meanwhile, I'm the Picasso of roasting your ass. You say you're over me, oh how cute, but here I am, still the star of your loop. You're my biggest fans, don't even deny, so grab some popcorn when daddy goes live. Live. Call me daddy, yeah, shout it loud. King of your thoughts, I'm making you proud. Papa Nut, Shizzy Daddy, headline act. Your background noise, and that's just a fact. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing cars, you don't know why. But here you are, barking while I touch the sky. Your comments are gold, such comedy gold. Who hurt you? Oh wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate watch my stream like it's Oscar night, but guess what, kiddos? I'm still shining bright. Call me daddy, sending your bread. I'm still rent-free in your effing head. Papa Nut, Shizzy Daddy on your brain. I'm your mental landlord, you can't complain. Let's keep it real. You hate that I'm winning, but you love how it feels. Oh, I'm sorry, did I break your streak? You tried to ignore me for like half a week, but daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there with your plastic clout, I'm here sipping coffee watching you freak out. You're relevant, wow, what a take. Now go rewatch my vids while I count how much I make. I count how much I make. Call me daddy, yeah, own it now. I'm reading your brain and you don't know how. Papa Nut, Shizzy Daddy, let's set the bar. I'm the constellation, you're a burned out star. Embrace your role, cause I'm the main character. You're just an old ragged ass, burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy Daddy's forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, your mental pain. Oh wait, you will see me tomorrow's agenda, will see me tomorrow. Same obsession, same effing thing.